Okay, let's unpack this one. Imagine you're in a really intense legal fight, right? And the things you say in court to defend yourself suddenly become the basis for a new lawsuit against you.
Yeah, it's a tricky area.
So today we're doing a deep dive into this really interesting judgment from the Bombay High Court. Came down July 17th, 2025. It's Criminal Writ Petition number 2686 of 2024. And it gives us this snapshot of how the Indian legal system handles that line between arguing your case and, well, defamation, especially in messy, emotional matrimonial disputes.
Exactly. What's fascinating here is how the court tries to balance things, protecting someone's reputation.
Right.
Versus the absolute need for people to state their case fully in court, even if what they're saying is, frankly, personally damaging.
So the big question is, when does a harsh statement, an accusation made in court, get legal protection? And when does it actually become criminal defamation?
That's the crux of it.
Okay, so the core conflict here. It started with a husband filing a case against his wife, and her family too, actually.
Right. Sections 500 for defamation and 506 for criminal intimidation under the IPC.
And the specific claim, the really personal one, was the wife alleging impotency.
A very serious allegation in this context.
And she didn't just say it once. It popped up everywhere in an FIR, the police report, in her divorce petition, which cited cruelty.
Section 13(1)(IA.
Maintenance petition under Section 125.
Yeah.
Even in a transfer petition up to the Supreme Court.
So these statements were central to her arguments across the board.
Definitely seems that way. So what happened initially in court?
Well, the first stop was the magistrate's court in Kerala, and they actually dismissed the husband's complaint right at the start. This was back on April 15th, 2023. They used Section 203 of the Criminal Procedure Code, basically saying there wasn't enough there for a prima facie case.
Meaning not enough evidence even on the face of it.
Exactly. The magistrate pointed out, look, impotency is a ground for divorce. These statements were made within those legal proceedings, and they also found no real evidence of criminal intimidation either.
Okay, it seems straightforward enough, but then here's where it gets really interesting, kind of a plot twist.
The appeal.
Right. The husband appealed to the additional sessions judge, and that judge, on April 3, 2024, actually overturned the dismissal, set it back down for more investigation under Section 202.
Which sounds like a win for the husband initially.
It does. But, and this is the kicker, the High Court later looked at this and found the reason for sending it back was, well, wrong.
How so?
The sessions judge claimed the husband hadn't been given a chance to examine witnesses. But the High Court pointed out, hold on, the husband never even raised that issue in his appeal.
Oh, wow. So the remand was based on a grievance the complainant didn't even have.
Precisely. It was an error that, could have dragged things out unnecessarily.
And this really shows why we have higher courts like the High Court, doesn't it? They can step in early. They have the power to quash proceedings, stop them dead, even before formal charges, if it's clear no offense is actually made out.
Like a filter.
Exactly. They even cited precedent cases, Arun Puri and Iviko Majiris, I believe, just reinforcing that courts can, and maybe should, look at whether these statements fall under the legal exceptions to defamation right at the beginning.
Okay, so the High Court then looked closely at the wife's statements, the impotency claims. Were they relevant?
That was the core question for them, and their answer was a clear yes. They concluded these allegations were, and I think the judgment used the words, very much necessary.
Necessary for her case.
Yes, and that she was justified in making those allegations to support her interest in the divorce, in the maintenance, basically in all the related matrimonial proceedings.
So legally justified, not just, mudslinging.
And this is the key legal point for you listening. The High Court found her statements fell squarely under Exception 9 to Section 499 of the IPC.
Exception 9. Remind us what that covers.
It protects statements or imputations made in good faith for the protection of your own interest or someone else's interest.
Good faith in protecting your interest.
Right. Because the statements were directly relevant to her ongoing legal cases and made to support her claims within those cases, the High Court said they were legally protected, not defamation, which also meant her father and brother shouldn't have been dragged into it either.
So the final outcome, the High Court essentially sided with the wife. They allowed her writ petition. They set aside that sessions court order, sending it back.
Undid the remand. Yeah.
And definitively dismissed the husband's original defamation complaint. Gone.
A complete vindication for her on this point.
So what does this deep dive really tell us? I mean, for anyone listening who might face a tough legal battle, it shows that while, yes, the law protects your reputation, It also has to acknowledge that inside a courtroom, especially in these really personal family cases, you need leeway. You need to be able to state your case fully.
It's a powerful statement about the boundaries of speech within legal proceedings. It recognizes the context.
It really is a complex balancing act.
Absolutely. And it leaves you thinking, doesn't it? How might this precedent change how people approach their arguments in court? Knowing that even very harsh statements might be protected if they're genuinely relevant and made in good faith to support your legal position, it certainly challenges us to think about the difference between, say, a random insult and a statement that's actually crucial for your legal survival.